Hello and Assalamualaikum everyone. My name is Ariani, and in this video, my friends and I will be discussing about the legal case in Malaysia of Siti Khadijah Apparel Sdn Bhd versus Ariani Textile and Manufacturing Sdn Bhd. This case is significant because it highlights the relationship between fashion design, art, and intellectual property law in Malaysia. This dispute arose when Siti Khadijah alleged that Ariani had copied the design of its telekung, resulting in copyright infringement claim. Through this case, the court examined whether fashion designs can be protected under copyright law and how intellectual property rights apply within the creative industry. It remains an important case in Malaysian law because it demonstrates the legal protection available for original artistic and fashion creations.
Assalamualaikum, my name is Jasnida Danish binti Azhar. And before discussing the case, let's look at the two companies involved. The plaintiff in this case is Siti Khadijah Apparel Sdn Bhd, a Malaysian company founded in 2009 by Patsila Endah Sulaiman. The company specializes in telekung and prayer-related products and is known for its innovative and comfortable telekung designs. Today, it is one of Malaysia's leading premium telekung brands. The defendant is Ariani Textiles and Manufacturing Sdn Bhd, which was founded in 2008 by Datin Seri Farah Ariani Muhammad Phillips. Ariani is a well-known Malaysian modest fashion company that produces hijabs, telekung, and Muslimah apparels. It has grown into one of the most leading brands in Malaysia's Muslim fashion industry. Through this, we can see the similarities between these two companies. The dispute began when Siti Khadijah alleged that Ariani had copied the design of one of its telekung products, leading to a legal battle over intellectual property rights.
Hello, my name is Christina binti Ahmad Rizal and I'm going to talk about the product in dispute. Before we discuss about the legal dispute, we need to understand the product involved in this case. A telekung is a special garment worn by Muslim women during prayers. It is designed to cover the body modestly and comfortably. In this case, the two products being compared were the telekung Siti Khadijah Classic by Siti Khadijah Apparel and the Ariani X Wow Telekung Nur Alisha by Ariani Textile and Manufacturing. Siti Khadijah claimed that Ariani's telekung looked very similar to their own design. The dispute focused on the specific design features such as shape, stitching, and overall appearance of the telekung. These similarities led Siti Khadijah to believe that Ariani had copied important part of their original design, which later became the main issues in court.
What happens when two companies sell products that look very similar? Is it competition or is it copying? In the case of Siti Khadijah Apparel Sdn Bhd versus Ariani Textiles and Manufacturing Sdn Bhd, the main legal issue in this case was whether Ariani had copied Siti Khadijah telekung design. Siti Khadijah claimed that Ariani telekung closely resembled its own ideas. According to Siti Khadijah, Ariani obtained its product, studied it, and reproduced similar features through a process known as reverse engineering. Reverse engineering refers to the process of analyzing an existing product to understand how it is made and then creating a similar version. The dispute was whether Ariani action amounted to an unlawful copying of Siti Khadijah intellectual property, or whether it was simply creating a competing product based on ideas available in the market. Therefore, the key legal issue before the court was determining whether Ariani had infringed Siti Khadijah's right by copying its telekung design through reverse engineering.
The relevant law in the dispute between Siti Khadijah and Ariani mainly falls under intellectual property law, which protects business identity and creative works. First, the Trademarks Act 2090 is important because it protects registered trademarks such as brands, name, logos, and distinctive product features. If one company uses a mark or design that is too similar to another, it may cause confusion among consumers and amount to trademark infringement. Second, the Copyright Act 1987 may apply if there are claims of copying original artistic element such as embroidery patterns, packaging, or promotional materials. This law protects original creative expressions from unauthorized reproduction. Lastly, the common law thoughts of passing off is also relevant. Passing off happens when one business misrepresents its product in a way that makes consumers believe they are associated with another established brand, causing reputational and financial damage. Therefore, this case highlights the importance of legal protection from branding, originality, and fair competitions in business.
Hi, my name is Siti, and I heard about the agreements by Siti Khadijah in the case of Siti Khadijah Apparel, Sdn Bhd versus Ariani Textiles and Manufacturing, Sdn Bhd. Siti Khadijah argued that their telecom design was an original creation and not a copyright from any existing design. Therefore, they claimed ownership of the copyright in the design and were entitled to legal protection. They also alleged that Ariani had copied substantial and distinctive features of the telecom, which amounted to copyright infringement.
Hi, in this part, I will explain the arguments presented by the defendant, Ariani Textiles and Manufacturing Sdn Bhd. Ariani denied the allegation that it had been infringed the copyright of Siti Khadijah Apparel Sdn Bhd. The company argued that the telecom design in question should not be granted copyright protection in the manner claimed by the plaintiff. According to Ariani, a telecom is a common prayer garment that has been widely used by Muslim women for many years. Therefore, many of its features serve practical and functional purposes rather than artistic ones. Ariani contended that this common design element should not be exclusively owned by a single company. In addition, Ariani challenged the originality of the telecom Siti Khadijah Classic. The defendant argued that some of the features claimed to be unique were actually common characteristics that could be found in other telecom designs available in the market. As a result, Ariani maintained that those features were not sufficiently original to qualify for copyright protection. Furthermore, Ariani argued that the similarities between the two telecom designs did not necessarily prove copying. The company stated that products with the same purpose and function often share similar design characteristics, especially within the fashion industry.
In this case, High Court ruled in favor of Telecom Siti Khadijah. The court found that the design of Telecom Siti Khadijah Classic was eligible for copyright protection under Copyright Act 1987. After examining the evidence presented by both parties, the court concluded that there were significant similarities between Telecom Siti Khadijah Classic and Ariani X-Wow Telecom Nur Alisha. The court held that Ariani had copied a substantial part of Telecom Siti Khadijah original design. Furthermore, the court rejected the argument that the design should not receive copyright protection simply because a telecom is a functional item of clothing. Instead, the court recognized that the creative and artistic element incorporated into telecom design were capable of being protected under copyright law. As a result, the court decided that Ariani had infringed the copyright of Telecom Siti Khadijah Classic. This decision was significant because it demonstrates the fashion design in Malaysia can receive legal protection when they satisfy the requirement of copyright law.
Hi everyone, today I will be discussing the significance of this case and its impact on the fashion industry. This case is important because it established the original fashion design can be protected under copyright law in Malaysia. The court decision recognized that creative elements in a fashion product are valuable intellectual property and deserve legal protection. The ruling has had a positive impact on the fashion industry by encouraging designers and brands to create original work rather than imitate existing designs. Also gives designers greater confidence that their creativity and effort will be protected from authorized copying. In addition, the case increased awareness of intellectual property rights among fashion business and highlight the importance of fair competition within the industry. By protecting originality and innovation, the decision helped support the long-term growth of Malaysia's creative and fashion sector. Overall, this case is significant because it strengthens legal protection for fashion designers and reinforces the value of creativity in the fashion industry. This leads us to the final part of our presentation, where we'll discuss conclusion and key lessons that can be learned from this case.
To wrap things up, The telecom war between Siti Khadijah and Ariani was never just a petty dispute over a piece of cloth. It was a historic battle over creative ownership. The High Court's decision proved that even a traditional religious garment can hold unique artistic value, and the law will step in to protect it if someone tries to copy it through reverse engineering. For us art students, designers, and future business owners, this case leaves us with two critical lessons. First, always document your process. Siti Khadijah won because they had the initial 2D sketches to prove their timeline. Your sketches are your shield. Second, inspiration has boundaries. You cannot simply buy a competitor's successful product, rip out the stitches, copy the pattern, and call it market research. That is a legal line you cannot cross. But this case also leaves us with a fascinating dilemma. Fashion naturally thrives on shared trends, borrowing ideas, and evolving styles. If copyright law become too strict, we risk choking creativity altogether. So, we leave you with this final question. Should all fashion designs receive copyright protection, or would that stop the natural evolution of style? Thank you.